Clayton Cosgrove.
Mr Chair, I just want to take a brief call again on the theme that a number of us have spoken about excuse me, this evening, of unconscionable conduct. And within the commentary, as I referred to before, it talks about unconscionable conduct applying is considered as unfair or unequitable or against good conscience to allow a party to enforce its contractual rights against another party who is detrimentally affected by an oppressive bargain. Now, in case the Chair may think that I'm wandering away from the bill, the phrase I want to concentrate on directly for a moment are the words oppressive bargain. And I'm going to illustrate the point by another government decision which two parties to which, sir, and you may have been distracted, sir, I'm referring directly to the words in here, oppressive bargain. And I'm going to illustrate that with an example. And the example is one of Rio Tinto. Two parties to a transaction, a contractual arrangement, yet one party negligently, stupidly negotiated a deal, paid a lot of money, gave away a number of components and got nothing back for it. Now, the question I'd have for the Minister, because she's a lawyer and she'll know far better than me, is would that be considered enforceable, given that Rio Tinto, not through any nefarious means but simply through good management, good negotiation and smarts, worked out that the government had nailed itself to a time frame to sell Meridian. Therefore, they waited until that timeline was almost going to be breached, and they sprung the trap. And the deal, sir, as I'm sure you and others will know, was that there was going to be job protection and all sorts of other things benefits to Southland New Zealand were going to rain from the sky, and the deal was done. And the deal was a halving of the notice period, a decrease in the power price for Rio, and $30 million thrown in for good measure. That was the deal. The question is whether that could have been deemed to be an oppressive bargain, given that one side got everything and the other side got nothing. And we know that before the ink was dry on the $30 million cheque, Rio Tinto had, through the Southland Times, indicated that maintenance jobs were going. We know now that there was no guarantee of those jobs encompassed in the deal, and further, we know that the Minister negotiating the deal, Mr English, never asked for a guarantee.
Never asked for it.
Now, that's the detail of a transaction. Never asked for it. So the question I'd have for the Minister and the Chair is, does this consumer concept of unconscionable conduct where the rights, where a bargain could be considered oppressive, apply to this particular transaction? It seems to me it would, because one side gave away not just the kitchen sink, but the kitchen and the lot, the whole house, and got back zero. Now, either that party could have been stupid, negligent, incompetent, or all of the above. But it seems to me, and I've never seen a transaction and a deal done, sir, where one side gives so much and gets nothing, absolutely nothing, back in return. Unless you count the fact that they managed to do the deal, therefore try and pump up the price of the Meridian float so they could get it away. I suppose you could say they got that out of it, they cleared the decks on that. But for $30 million, a halving in the power price, no jobs guarantee, and a decrease in the power price and a halving of the notice period, the question I'd have is, what did we, the Parliament, on behalf of the taxpayers, get for that? Now, I'd call that an oppressive bargain. I don't blame Rio Tinto, because Rio Tinto's job is to get the best deal that they can for their shareholders. And to quote the Prime Minister, if they're dealing with a bunch of muppets, which they were through the Finance Minister and negotiators, then, so be it. But I'd like to know from the Minister if that particular transaction, $30 million, would constitute, sir, an oppressive bargain, and in doing so, unconscionable conduct.
Jamie Lee Ross.
Move that the question be now put.
The question is that the question be now put. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. We now move first to the Minister's amendments as set out on SOPs number 273 and 404. The question is that the Minister's amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. The question now is that Part 1 is amended, Part 2 is amended, Schedule 1 is amended, Schedule 2, Schedule 3 is amended, Clause 1 and Clause 2 is amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Stand up.
Mr Chairman.
The Honourable Amy Adams.
Mr Chairman, I move supplementary order paper number 405 dividing the bill.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. I will report this bill with amendment and so divided presently. Members, we now move to further consideration of the Arts Council of New Zealand, Te